Ready to go? Okay, one more quick announcement for our audience. We have a microphone over here for recording. We don't have an amplification microphone. I want to do a quick audio check. For those in the back, can you hear me okay? I'm getting 2 yeses and 1 no. A little bit louder. I'm getting 3 yeses and 1 no. Are you feeling in the minority, Kate? We will try to make sure that we're projecting. I also want to make sure that Manny's earphones back there are popping because of the microphone up here as well. Okay. But thank you for that feedback. We'll definitely try to pump up the volume.
Just use your classroom voice.
My classroom voice? Okay.
Yes.
We have different size classrooms. Okay. All right. Well, I'd like to welcome everyone to our first session on the reality behind the rhetoric. Our first topic will be on U.S. immigration policies. So welcome audience members. I'd also like to welcome our audience through video recorded means. And also welcome to our panelists. I'd like to introduce them to you. On my far right, we have Mr. Sala. Mr. Sala is a State Bar of California legal specialist in criminal law and has had that distinction since 1995. He has a Martindale-Hubbell peer review rating of AB preeminent, which is the highest rating of professional excellence earned through peer review. We also have Mr. Wynn Eaton, who is also a State Bar of California board certified legal specialist in immigration law and nationality law. He also works in the area of citizenship and family immigration, including removal, defense, consular processing, immigration court, and federal appeals. Welcome, gentlemen.
Thank you, Manny.
Today's session will include our panelists' response to questions that have been prepared in advance. However, we welcome your questions. Feel free to send your questions our way through means of the cards that have been distributed to you on the way in. And time permitting, we will ask as many of those questions as we can at the end of our session, which we hope to have at least 15 or 20 minutes allocated for that. I do want to clarify that the purpose of our session today is not to take a political stance or cause or any position of that nature. It is simply to provide timely, accurate, and helpful information to our students. So with that, I wanted to begin our time with asking the first question to Mr. Eaton. Right now, if a student is enrolled in a California college under DACA, what should they anticipate in the next year?
Well, that's a very good question. We've just come out of a lot of hot rhetoric in the political campaign. Now it's time for governance. And the president-elect is in the process of assembling his administration, his cabinet. The 2 positions we were keenly watching have both been announced now. The first was Jeff Sessions. I want to make very clear that the Attorney General does not directly influence immigration policy. The Justice Department that he would be in charge of will be in charge under his purview, or will be the immigration courts. So unless somebody has been issued a notice to appear and is in the immigration court removal proceedings, the Attorney General does not have direct jurisdiction. The other position was announced yesterday. Some of you may have heard. It's John Kelly, a very outspoken Marine Corps general from Boston. He carries all the Boston flair and the deep, bombastic tone. He's very opinionated, but I'm optimistic that General Kelly has ideas of rebuilding the economies in Central and South America and Mexico and helping to facilitate a stable, safe environment to stem the flow of recent arrivals and all that. But back to the question, what should we do? What should we anticipate, in particular for DACA? I think we can all rest assured DACA is going away probably shortly after January 20th. And I know that sends panic on first blush. However, I'm optimistic there too. And I don't think there's a great deal of probability in negative consequences coming from going away, the expiration or the repeal of DACA. And here's why. DACA is an enforcement priority. And first of all, that's why the president, and we'll get this in another question, or that's why the president-elect, when he's sworn in, can reprioritize enforcement resources. It's not a regulation change, such as some of you are familiar with the, and I hesitate to use too much legal rhetoric, but the I-601A provisional or stateside waiver showing hardship on a husband or wife or parent. That is a regulation change. That's going to be a long time before they're able just to undo it, okay? So because DACA is an enforcement priority, we believe it is going to go away. But just yesterday, the president-elect, and I want to believe he's sincere, has committed to finding a way to deal with a real DREAM Act. Everything with the president-elect is fantastic. Everything is going to be the best ever and extraordinary. And we want to believe him on this front. Rahm Emanuel visited with the president 2 days ago, and after that meeting, he now is beginning to understand some of the complexities. So how, you know, and just a little bit of historical context here. We essentially, California, New Mexico, Arizona, and Texas, not that long ago, were Mexico. And so at some point, we started to bring this invisible wall down, and wherever it landed on the date that U.S. law or Mexican law was enacted, people were stuck on one side of the border or the other. Well, all these generations now, we've continued to intermingle and interreact and marry and give in marriage and all. And so it's humanly impossible, I believe, to arbitrarily separate families. You can't build a wall high enough, you can't build a moat deep enough and fill it with enough alligators or electronic surveillance, or whatever you're going to do to keep families apart. You can't keep families apart. And this all goes, I suppose, along with what I would call the Churchill analysis for American policy. Winston Churchill said, you can always count on those Yankees to do the right thing after they've tried everything else. And that's what's going on. For the last several years, since 1996 in particular, when we got the most draconian immigration law in recent history, next to the Asian Exclusion Act in the 1860s, or the 1880s, this act in 1996 was where we got the 10-year bar and the 3-year bar that forced people out of the country and said, okay, yeah, you can come back after you spend time away from your family for 10 years. Oh, but we'll make an exception if you can show extreme hardship, unusual hardship on a U.S. citizen, either parent or spouse. Children don't count. And I think the folks that came up with this in 1996 really did a disservice to mankind. And the chairman of the Homeland Security Committee and the Judicial Committee in the House, both Republicans, of course, have now acknowledged that maybe the 3-year and 10-year bar are not such a good thing. So in context, what do we do with people on DACA? Continue doing what you're doing. If your DACA is valid, I don't believe they're going to be able to roll back and take that away from you. I expect that there will be some policy change. The government is allowed to look at DACA applicant information. They can use it for law enforcement, but under the stated policy, they cannot do so unless a person is subject to a notice to appear. And that means they've been put in deportation proceedings. So, in summation, on this one question, Manny, thank you for indulging me here. I don't expect a great deal of problems in the expiration of DACA. You may be surprised to hear me say that, but understanding the big picture, understanding how the political system works, it would just be impossible at this point, I believe, to try to implement a full enforcement policy that would include DACA recipients.
Mr. Sella, did you want to add anything?
Yeah, could I just add something? You know, we're looking at the practicalities of what would happen, even if President-elect Trump, which we expect he will do, rescinds President Obama's executive action regarding DACA. The practical effect, how is that going to be put into place? The Speaker of the House has already indicated that they will resist any mass deportation force or add immigration agents, if you will, to effect mass deportations. Also, the President-elect has also indicated that his priority is to begin removal of those immigrants that are here undocumented that have criminal histories, that have been detained, found guilty of criminal offenses. So there's going to be priorities. So as Mr. Eaton has suggested, the priority of trying to go and seek out DACA students is extremely low. It really is not a priority. So people should not be overly anxious that in the next year ICE agents are going to show up on your door and try to deport you. I just don't believe, in my view, that is practical. It's not practical at all. And we'll get to some other issues as we get related to that as we get into other topics.
In 2012, when President Obama enacted the Deferred Action for Childhood Arrivals, what was the rationale for implementing that executive action, and what are some of the rights and privileges that go along with students who fall in that category?
Okay, we all know the picture. Let's say somebody is a small child, you're days, months, or a few years old. You don't have the ability to decide where you want to be, where you want to live, and who's going to feed you. It's going to happen, and you're kind of the victim, so to speak, of those around you. So you're brought to the United States, and I think any reasonable thinking human being knows the right thing here. These kids are all innocent. They've done absolutely nothing wrong, and the very title that they're, quote, illegal, I think, is highly offensive, and most any reasonable thinking person would agree. Having said that, the government was faced with a dilemma. The law in 1996 was written in a very draconian and harsh fashion that made no exception for innocence. It made no exception for hardship in these cases where somebody is in the United States without documents. What do? The child may have been through the United States school system, married their high school sweetheart, have 4 or 5 or 6 kids of their own. They may be working, carrying on a great career, and then at some point find out, I wasn't born here. It happens all the time. They maybe don't even speak their native language. So the government was faced with a dilemma. It was more than a dozen times, 15, I think maybe 17 times, we've tried to deal with the problem, and we've been caught in this political quagmire of the Republican versus Democrat House and Senate members unable to agree, and we each party wanted to grab a handle and use that as a wedge for some other political purpose. That's where we've been. So having said that, let's go forward to 2016, November the 8th, we elected a new government. What's interesting about this government is the United States is facing a number of perplexing problems. For the first time since 1928, this is nearly 90 years, we've elected on the front end a new president with a unity government in the House and the Senate. Fairly substantial majorities, so all of those perplexing problems are now in the lap of the Republican administration and the legislative bodies. I think they deserve a chance over 89 years to have an opportunity. Let's see what they're going to do. The rhetoric, I wish we could find some way, like it was a big, last 2 years is just, think of it as an Etch-a-Sketch. It's now flipped over and it's all erased. All the rhetoric is gone. There's been some come-to-Jesus moments with the politicians from top to bottom, and a lot of the talking heads, you might see them on Fox News or other places, are very concerned now that the president-elect would have the audacity to grab somebody like Mitt Romney and even consider him for Secretary of State. Well, that all should give the country a little bit of comfort to understand that maybe there is some competence coming out of the administration, coming out of the legislative bodies, and that's why I want to be optimistic here. I think there's plenty of reason to be optimistic that when the dust is all sorted out on the issue of the DREAM Act, I believe even if they want to do piecemeal immigration reform, which I think will be a colossal disaster, but I'll try to avoid interjecting my opinion very much because it all comes out in what I say anyway. When it's all said and done, we're going to do the right thing on the DREAM Act. We've been trying all the alternatives for a long, long time now. It's not working. 20 years since IRA was passed in 1996. It's time to get real and solve problems. We have a unity government. They have absolutely no excuse but to do the right thing. So let's give them a chance.
Mr. Sella, what process must be followed to amend laws or to revise policies? What steps are required to be taken for that to occur, and what's a realistic timeline for those actions to occur?
There's two components of that. One is in the context of, let's say, DACA executive action. It's anticipated that the president-elect will do just that and repeal the executive action taken by President Obama. So that's one component of it, but he cannot unilaterally rescind or change statutes or laws that are in effect because of the Constitution and Articles 2 and 3 of specifically of the Constitution that would require Congress to modify or change existing laws. It would also be subject to any judicial action that might be contemplated by way of an injunction or a lawsuit to stop any action by the executive branch that might usurp the authority of the legislative branch. So I think what we all need to realize is that the Constitution is the controlling force in this country, and not a single individual, including the President of the United States. And people should take comfort in the protections that our Constitution provides to all of us. That document has been in effect for over 200 years and serves to protect the liberties of all of us, whether you're documented or not. And I think we need to realize that and put aside all the rhetoric and the that we hear from, and we've heard from the president-elect. There is that document that protects us, and so he cannot simply repeal existing laws. That cannot be done. He can take executive action, but that is subject to, and we don't know what could happen as a result of that. If he were to, say, repeal DACA, there could be action taken by various groups that have, for example, filed suit against Arizona when Arizona tried to deny DACA students or DACA individuals driver's licenses. Injunctions were filed, and ultimately found that the Arizona statute was unconstitutional because it violated equal protection. We would have to wait and see what happens if the president-elect does take action to rescind DACA, because DACA in effect has created, in my view, an entitlement I mean, individuals have relied on the provisions of that particular action taken by the president. Whether that raises issues of that rise to a constitutional level, I don't know. There'll have to be civil rights lawyers that may take a look at that and may consider taking some action against that. We should also consider that the governor recently appointed Xavier Becerra as the Attorney General of California. And Mr. Becerra has already taken the position that he will sue the federal government if the federal government interferes with basic rights and privileges and liberties of the residents of this state. And I believe that he will keep his promise. This is something that states have done on many occasions where the federal government has treaded upon the rights of the states. They'll sue the federal government. In addition to private lawsuits and public interest groups, we're not out there in the wind. Even if President Obama's executive action were to be repealed, there is still, I think, in my view, considerable protections that the laws provide that could result in injunctions being filed, lawsuits being filed, and the timeline, who knows how long that could be before anything is resolved. So the point that I'm making is, we have so many protections here and so many avenues that we can take advantage of to analyze and attack, if necessary, in the courts, the president-elect's actions that we expect he will make.
Mr. Eaton, DACA is subject to eligibility requirements and also is subject to renewal. So for individuals who have not applied for DACA status, or for those who are considering renewal, would you recommend that they begin that process? And could you also talk to us a little bit, excuse me, about advanced parole and
Sure.
how that might benefit some?
Okay, now, before we do that, a couple of things may I add to Beto's comments. There was an old case, and before we get into the professorial mode here and start belaboring the point, an old case, I believe it was called the Stranahan Steamship case back in the early 1800s, that pretty much established the limited rights of non-citizens in the United States. And there are some that have clung to some of those old decisions from the 1800s. We had the Free Whites Only Act, 1821. We had the Asian Exclusion Act of 1886, and the last vestiges of some of those very draconian bits of legislation were still in effect here until 1952, when we passed finally an Immigration Reform Act, which is the fundamentals of what we operate with today with the modifications. I say that because it's important to note, and I don't want to cause alarm, but there are a limited set of rights for non-citizens without documents in the United States that a lot of times judges, in fact, can I tell just a brief story? I was at the Reagan Library. I was on a panel with the Federalist Society, and there were a group of attorneys, and we had Judge Kaczynski and Judge Reinhardt, and those are two diametric opinions on the Ninth Circuit. And as I'm saying this, I'm thinking I may get in trouble with Judge Kaczynski, but fundamentally, I was carrying on as kind of a cerebral sort of a group, and I was very concerned about the fundamental right to marry that the Supreme Court gave us in a case called Loving v. Virginia back in the 1960s. And I was making a case. We don't have a fundamental right to marry who we want in the United States anymore after 1996 because of this separation. So Judge Kaczynski stood and says, "Counsel, you're wrong, because we make special provisions for U.S. citizens." So I had this open debate with Judge Kaczynski at the end of the session, well, before the session ended. Each of the other attorneys said, you know, Mr. Eaton is exactly right, Mr. Eaton is exactly right, Mr. Eaton is exactly right. Well, at the end of the session, Judge Kaczynski grabbed me by the arm, marched me down, and we went out, and for the next 45 minutes, we debated the fundamental right to marry and the 10-year and 3-year bar. And to his credit, when it was all said and done, he thanked me and said he'd learned something there today. So there's a lot of misunderstanding about the rights of non-citizens in the United States, and the same applies here. We need to, and I've printed some things here both in Spanish and in English. This is from the American Immigration Lawyers Association, of which I'm a member and on their national committee. These documents are helpful to understand your rights in just a one-page thing. What do you do if you get apprehended? And understand that immigration law, and particularly deportation proceedings, are not criminal matters. There is no Fourth Amendment, Fifth Amendment right to counsel. You're entitled to due process, and that's the key. Those two words, due process, is the totality of the rights that you're entitled to as a non-citizen residing in the United States. Okay, so the question was, what should we do if we're DACA? DACA now?
Should some individuals who are eligible for DACA, should they apply, or those who are eligible for renewal, should they renew, given some pending changes? And also, if you can talk to us a little bit about advanced parole.
Okay. Let me tell you that since the 9th of November 2016, my office has been absolutely inundated with news media and inquiries, clients and prospective clients wondering what to do. And a lot of the conversation and the consternation is on this very topic of what to do. So let me cover those very quickly here. Is if you're a new DACA applicant, I don't see it worth your time to pay the $465 fee or to pay an attorney or somebody else to help you file. I think that's a waste of time. That ship has sailed. If you haven't applied for, haven't been granted DACA, haven't applied yet at all, forget about it. It's done. Let's wait and see what happens after January 20th, okay? I want to be very clear about that. My advice, it's only my opinion, is there's no point in applying at this point. Same thing would apply for advanced parole. Now, to clarify what advanced parole means, there are two ways to get a green card in the United States. One is what they call consular processing, where you have to go out to the consulate and come back. Anybody who was not inspected and admitted at the border, and that means you came in, how to say, Portocero, through the hills, maybe using false documents at the border, but that has a different connotation. But if you came in without inspection, that means the border guard looked at you, the border guard waved you in or paroled you in. If there's no inspection and admission or parole, then the only way to get a green card is to leave the country and come back in through the consulate. In order to do that, you trigger, the moment you leave, the 10-year bar if you've been 18 years and 6 months in the United States, or at that age, if you've been in the United States more than 365 days and you're beyond 18 years and 6 months and 1 day, then you're subject to consular processing, you're subject to the 10-year bar the moment you leave. And that's where we get into the hardship waiver and all that. The other way to do it is what they call adjustment of status. That's a term of art. You're applying for a green card based on a family petition, either a spouse or a child for a parent, and the person is in the United States having been inspected and admitted or paroled. So we came up with this legal fiction that said, okay, we're going to allow people to be paroled back in the United States, and they call that advanced parole. So generally advanced parole applies to somebody who is in the process. They filed the I-130 petition from a spouse, let's say, and they're waiting for their green card interview to happen in Fresno or wherever it's going to happen. And during that time, they're authorized to work. And so they issue a work permit, and now they issue the work permit with the advanced parole 512 authorization on the same card. So you can actually leave and be paroled back in. Okay. one of the provisions in the DACA measure that, or the DACA enforcement priority that was given to us in 2012 was the ability, if we can show that the individual DACA recipient has extreme need to travel. That means there's a life or death situation. There's a lot of times it's a grandparent with a health problem, with cancer, or whatever it is, an urgent need to travel. Now, we actually got one for a young lady who was valedictorian of her high school. She wanted to go down and she wanted to be a doctor. She wanted to go to a medical school, and she couldn't afford it here, so we told them she needed to go to Mexico and look at medical schools. It was granted, but that was early. I don't think they're doing those anymore. But it could be employment related. It might be a truck driver that needs to go down on a special trip to move a bunch of equipment up. But anyway, they were granting these advanced paroles, and lately they've really tightened up. We're saying now it's too late. That ship has sailed, because now the enforcement priorities at the Customs and Border Protection are scrutinizing these things so strictly that it's conceivable to me that somebody who travels on advanced parole now could be stuck outside the country, and then you're subject to just a consular process and to get back. So I would be very careful with advanced parole now. I'm singing a different tune now than I did last summer. I was saying, let's get it done, get you out, get you back in, whether you're married or not. Someday you might be, and by the way, you're only allowed to date U.S. citizens. And then we would have a way to apply for the green card. Okay.
Mr. Sella, we started to talk about constitutional rights for non-citizens. Could you expand on that a little bit? Fourth and Fifth Amendment rights, for example.
Mr. Eaton addressed, limited rights for non-citizens, particularly in immigration proceedings. However, when it comes to the protections of rights guaranteed by the Constitution outside of that context, immigration proceedings, constitutional rights under the Fifth Amendment, your right not to say anything that might have a tendency to incriminate you when you're contacted by law enforcement, your right to remain silent, your right to a lawyer, your right under the Fourth Amendment to be free of unreasonable searches and seizures, to not be subjected to searches without a warrant. Those rights apply to everybody, whether or not you have legal status here or not. And by that I mean, and if I could expand a little on that, if a law enforcement agent, police officer, immigration agent, immigration customs enforcement agent, if they come into contact with you, you do not have to answer any questions concerning your legal status. You have that right, and you should exercise that right and not say anything about that. If you're stopped, the stop of a vehicle has to be based upon specific and articulable facts that a crime has been committed. You cannot be stopped simply because of the color of your skin. That's illegal. So they have to have at least a reasonable basis to effect a stop, to stop you on the street. They have to have a reasonable basis to do that. You do not have to agree to a search under the Fourth Amendment if they do not have a warrant, and you should exercise that right. You should not allow your individual person to be searched, your vehicle to be searched, nor your home. You don't even have to, if someone knocks on the door, an ICE agent or a police officer, you don't even have to answer the door. And you shouldn't answer the door. And certainly should not agree or allow or consent to a search of your home. that those are protections that everyone has. And those rights should be exercised, particularly in what could come to be in the future, and that's very important. Some people think, well, I have to answer the question, I have to agree to a search, or they're going to take me to jail. I mean, you cannot predict what the individual officer is going to do, but there is a way to handle that also in a respectful manner, to tell them that I'm not going to answer any questions, or I'm not going to agree to a search, without escalating the situation. That's very important. And I want to stress that when if you come into contact, the individual comes into contact with law enforcement, you want to be respectful, and you do not want to be baited by the police officer and let your emotions get in the way and perhaps make any derogatory remarks or anything that might cause a police officer to overreact and then escalate the circumstances that could result in an arrest. Most police officers, if you treat them with respect, it's expected, hoped that they will understand that you have these rights and will respect that. Of course, we've seen a number of exceptions, but it is important at least to keep that concept in mind when you're dealing with law enforcement, that you do not want to do or say anything that's going to escalate when you're invoking these basic constitutional rights. So.
I want to ask one more question of our panelists, but at this point in time, if you're interested in having your question
So, man, hold on, before we do that.
asked and answered, if you could just move your card toward the middle of I'll just kind of pass it toward the middle and then toward the back, and I'll make sure that those are collected over here. Mr. Eaton, did you want to interject?
I do have a couple of comments there about Beto's world involves state and federal and local law enforcement. Welcome to my world. It involves federal immigration law enforcement, Customs and Border Protection officers, and the immigration and customs enforcement officers. Our world is not governed according to the criminal procedures, federal criminal procedures. It's all federal rules of civil procedure and the Administrative Procedures Act. So Beto is absolutely right about claiming your rights, exercise your rights. But let's talk about a couple of things just briefly here. We had a young lady selling flowers for her church on the corner of Union and Brundage here a few years ago. And immigration officers saw that she was dark-skinned, black hair, short. She must be illegal. So they pulled their van over and asked her if she had a license to do what she's doing. Immigration Customs Enforcement has nothing to do with municipal court enforcement of selling flowers on a street corner of Union and Brundage. But she didn't know that, and she got very nervous, and she just locked up. She passed out. She was so afraid, she passed out. They took her into custody. It was 3 weeks before the family got a hold of my office, and we sued them. And we learned a lot through that suit about the way customs enforcement works here. But bottom line was, we filed a motion to suppress the arrest and any statements that she made subsequent to that, because the entire process was based on racial profiling, and they had very little defense against that. So Immigration Customs Enforcement is permitted to ask who you are, where you live, and basic questions about your life and existence. What you have the right not to answer is your nationality questions. Anything that goes to your nationality, if you're not a citizen of the United States, just shut up already. there's a legal presumption in the law that anyone who's physically present in the United States is here legally. Don't allow that presumption to be shifted. That's my advice, is answer their questions, be friendly, be cordial, be honest, but the moment you hear two types of questions, and these will be framed differently. Where are you from? So, oh, I'm from Connecticut, wherever you lived last. That's okay. But really, what they're going after is, what country are you from? And if you answer them, oh, I'm from Mexico, you just shifted the legal presumption. Now it's your job to prove that you're here legally. So, oh, well, gee, what is your status? Ain't got none is not a good answer. The other...
What is a good answer?
A good answer is, officer, I've done nothing wrong. Why are you asking me these personal questions? And say, you know what, I'm afraid I just can't answer your questions. You know who I am. I've told you honestly. I'm trying to be friendly and helpful to you, officer, but I don't feel comfortable in answering these questions without benefit of counsel. Now, some of our business cards, this is the only commercial you'll get today. I put on the back here the magic words, to whom it may concern, please be informed that I am choosing to exercise my right to remain silent and the right to refuse to answer your questions. If I am detained, I request to contact an attorney immediately. I am also exercising my right to refuse to sign anything until I consult with my attorney. So most of our folks have this right in their pocket, in their wallet, multiple copies, stuck in their shoes, in the glove box. They're all over the place. And at some point during the interview, be prepared to say, officer, I'm sorry. Just hold the card up, zip your lip, and be prepared, though, you're going to be detained. And it may be an extensive detention.
And along those lines, often you'll get law enforcement agents not settling for the invocation of your right. They're going to try to
Yes.
intimidate you.
That's
They're
right.
going to use a number of techniques that they're trained to do to get you to make a statement against your interests, or a statement about your nationality. And you have to not let them bait you in that regard, or not let them convince you to say something. You have to continue to be cordial and say, I'm not going to answer the question. And you have to be firm, because they're going to try to overcome your will. That happens in my world frequently. They'll play good cop, bad cop. They'll tell you, look, it's better if you talk to me, if you answer my questions, it's not going to go as bad for you. If you don't, I'm going to take you to jail. But ultimately, what I've found, at least in my world, if you continue to assert your right, in the long run, it is always in your best interest to do that.
Two final points on this, and then I know we need to move on. Number one, assume that all police cars are wired. If they put two of you in the back of the police car and you're carrying on a private, well, what are we going to say?
Yeah.
You're done. Everything is recorded. Just know that on the front end. The other thing is, just know that when you're detained by immigration, you have a right to private counsel. You have a right not to say anything further to them once you're detained. If you're falling into a category of certain individuals where you've been deported in the past, you might be subject to what they call reinstatement. That's bad news. You have very limited time. If someone you know is detained and they're subject to reinstatement, that means that the old deportation order is going to be reinstated against them. You can be out of the country on a bus in a matter of hours. There's very little appeal to that process. But if somebody is detained under those circumstances, please have the family contact a competent immigration attorney immediately. And that means if you get picked up at 6:30 in the morning, by 6:30 our phones should be ringing. Somebody's phone should be ringing, because it takes time. We can draft an emergency motion. We call it a fire drill in our various offices. And we have attorneys waiting in the courts in San Francisco that are going to file those motions to reopen, or an emergency motion to stay, or we're going to file a request for a stay of removal with immigration. Once that's filed and feed in properly, then everything stops. And it gives us time to catch our breath. But if somebody is subject to a prior reinstatement, we need to act very quickly. Anyway.
I'm going to ask Dean Rodriguez to collect your questions, if you don't mind. And while he does that, I'm going to ask Mr. Sella, we talked about detainment. Under what situation or circumstances can an individual be detained, and what's the legal standard for detainment?
In the context of what I practice in criminal law, any law enforcement agent, and assume that applies to an immigration customs enforcement agent, because if one of those agents detained my clients, I would be able to challenge that detention. That detention, if they do not have a warrant before they can stop you in your vehicle, by activating the red lights of the patrol vehicle and pulling you over, before they can tell you to stop if you're on the street and tell you, come here, I want to talk to you. Before they can do that, they have to have very specific facts, and they need to be able to articulate those facts that you have been involved or about to be involved in criminal activity. And those facts have to be not just what the officer believes them to be, they have to be objective. So they cannot just stop you arbitrarily. And you're not required, if an officer approaches you and says, I'd like to talk to you, which the law considers that a consensual encounter, you don't have to stop and talk to them. You can continue on your way. But before they actually restrict your freedom of movement, they have to have very specific facts to believe you have violated some statute or committed a crime, or you're about to commit a crime. So they just can't legally, indiscriminately stop you or your vehicle without that legal standard.
And Mr. Sella, we have a question that is similar to that. One of our audience members asks, if an individual who has a green card is detained by law enforcement, can they be deported? If they're in possession of a green card, can they be deported? I guess that would be a question for Mr. Eden as well.
Mr. Eden.
No, if somebody is, let's see, let me get the question correct here. It says, if an individual who has a green card is detained by law enforcement, can they be deported? Well, it depends. There's only one essential ingredient here that would cause somebody with a green card to be deported, and that's if they're subject to some prior order of removal, where they've lost their green card in the past. If somebody has a green card, you're a permanent resident of the United States. If your green card has been expired for 15 years, you're still a permanent resident of the United States. Your status is not necessarily key to the expiration date on the green card. But every person who's a green card holder is entitled to that due process we talked about a minute ago. And that means you're entitled to go through the process of removal before an immigration judge.
And to add to that, and I want to stress this because I have this come up many times in my practice, I have clients that became permanent residents when they were children. Mm-hmm. And for whatever reason, they do not become U.S. citizens. Then, as an adult, they become involved in the commission of a criminal offense. And if that results in a conviction for certain types of crimes, firearms, domestic violence, if the narcotics, and the case is adjudicated, unfavorably to them. They're convicted of that one of those offenses. And it gets complicated. There's a number of criteria that Wynn and I work on, try to avoid those consequences. Even though they have a valid permanent resident card, after they complete whatever sentence is imposed in the criminal case, they are often delivered to ICE and then placed in removal proceedings, and ultimately can be removed from or deported from the United States. So I always, tell my clients, if hopefully if they were not placed a hold placed on them, that please either stop getting involved in activities that can get you in trouble, or apply for citizenship, because it happens all the time. We work together on cases where we have non-citizens, and I'm representing them on a criminal case, and I call Mr. Eaton, and we try to work out a resolution of the criminal case that will not result in the client, after the terms of the sentence are served, result in the client being placed in removal proceedings.
And sometimes that's very difficult.
It's very
You've given me some really difficult cases, but generally it works out.
Yeah. It's difficult to avoid that when the client gets
There is one thing
convicted
along
of
those
20 pounds of methamphetamine.
There's one thing, I just want to be clear that if the standard is so different in the civil realm that I practice in immigration law. For instance, the government doesn't need a criminal conviction in some cases if they have reason to believe that a serious crime or a drug trafficking or something has gone on. Reason to believe is not the standard of beyond a reasonable doubt. And that's where I know when Beth and I talk about these things, it's hard to get your mind around the concept that consequences in many of our cases are so severe. We're talking about life and death, removal to a country where the person is probably going to be murdered, and we're dealing with the standard of no criminal conviction, just the government has reason to believe. So that's the standard. And the other issue there is, if somebody is convicted of a drug offense, most all drug offenses are considered aggravated felony, sometimes even if they're misdemeanor in state courts. If somebody is convicted of an aggravated felony, they could be subject to what's called administrative removal. And that's where it's all done within Homeland Security, and a judge signs off, but the individual's never been before the judge. So just so you know.
Thank you. We have another question asking, if a DACA student was scheduled to exit and re-enter the U.S. after the inauguration, should he or she follow through given the risk of being denied re-entry? What if he or she has kids who are U.S. citizens?
If you have advanced parole authorization now, with proper advisal, I'm going to tell you, it's risky, but at this point, I would say if you could go out tomorrow and then come right back right away, I would say do it. If you have some method for adjusting status once you're complete with the advanced parole process. But after the president is sworn in, no. I would not advise doing that. Because even now, Customs and Border Protection can deny your entry on frivolous grounds. And they have not been doing that I'm aware of. If you hear of cases like that, we'd like to know about it. We have a team of folks that can very quickly respond with litigation and tie it up. But after the 20th of January, I would not advise a DACA recipient to travel on advanced parole.
Thank you. Another question asks, for family petitions, what can I do to, I'm assuming it means to move them along. I have a petition from 2006.
You ask a question about our visa bulletin. The Visa Bulletin is run by the State Department. It's a mystical thing that goes on within the State Department. It's published every month that tells where the priority dates are. I assume that's what you're talking about here. If it's a 2006 petition, it might be a sibling, a U.S. citizen sibling petitioning for a brother and sister who's a foreign national. And right now, most of those are down in the 1990s. We're waiting for the Visa Bulletin to become current. So talk to me specifically about your case. I'll try to deal with it, but it's too complex to just deal with it in a general answer here. But let me interject an opinion about this whole Visa Bulletin thing. I just pray to God that someday we can get to a place where we have in this country a colorblind, nationality-neutral policy for people of all parts, corners of the country. As it is now, we have one category for all of the world except 4 countries. If you're from Mexico, the Philippines, China, or India, you're subject to this Visa Bulletin backlog that in some cases goes on for many, many years. Even on the face of it, the Visa Bulletin, let's say for a, let's say you have a senior citizen, somebody who's 80 years old, and they have a son or daughter, and they're kind of starting to fail, and say, yeah, gee, the body's shutting down. I sure wish my daughter was here. She's a nurse in India. Why can't she come and take care of me in my old age? Oh, I should file a petition. She contacts government. Yeah, you got to file an I-130 petition. The I-130 petition takes about 6 months to process. It finally gets approved. They think they got something. No. Now it goes into the backlog in the Visa Bulletin. The backlog is sitting back in the early 1990s someplace. And we did a calculation, and these are real numbers. We said, okay, if you file the petition on the 8th of December 2016, how long will it take somebody from the United States, a U.S. citizen parent, to bring their adult son or daughter, let's say, from Mexico City? We calculated. If you base the date of arrival of this child, or this adult son or daughter, on what's happened over the past 15 years, in the United States, how much the Visa Bulletin has moved, you're looking at 135 years. So when any of these talking heads want to describe to you why do these people want to jump the line, there is no line. There's effectively no line. 135 years for somebody that's 82 years old is unacceptable, wouldn't you say? All in favor? Sorry.
All right. We have time for one last question, and I know that there were several others, and I do invite our panelists, time permitting, to interact with our audience. This is our last question for this session. What are the penalties for a business owner to have undocumented workers working for them?
My first comment is, if you're a business owner, you don't have undocumented people working for you. Be careful what you know. Constructive knowledge is dangerous. Don't go to the birthday parties and family get-togethers, and don't invite your employees necessarily to, and I know people become a part of your life, and they're like family, but be careful about the I-9 issues. I-9 is where you're declaring as an employer that you've checked the documents to make sure that you have valid employees and their authorized employment. So this is, again, not a question you can answer in a very brief setting. I give seminars on I-9 compliance and E-Verify issues. So if you're an employer, particularly a major employer, major industries, you could check with some of the agricultural groups that we occasionally will talk with, and jump into one of those seminars, and you learn a lot of details that you really need to know if you're an employer, and there's a possibility that you have people that have Social Security no match or other issues that need to be dealt with. But fundamentally, be careful of constructive knowledge. If you see a Social Security card on an I-9 compliance application that the Social Security number is crooked, the spacing's not right, the names are misspelled, you probably have a problem. That is going to have ramifications for you, because they're going to say you either knew or you should have known. And we have a whole nother process if someone is targeted for enforcement by ICE as a business, then you need to know your rights there to avoid some very, very substantial financial penalties. Now, one more issue on this employment thing here. and this is something a lot of attorneys, I get frustrated, are not aware, and even if they've been practicing immigration law for a very long time. You have somebody who is a foreign national married to a U.S. citizen. The U.S. citizen files an I-130 or 45 package, and you're applying essentially for a green card. There is, in the Immigration Nationality Act, a whole list of bad things that will happen if you work without authorization. Down at the bottom, there's a fine print note in the law that says none, and I say that broadly, none of these penalties apply to an immediate relative of a U.S. citizen. So the bottom line, if you're an employee and you're in the process and you're married to a U.S. citizen, you're not subject to sanction. And when you get to your interview in Fresno, and the interviewing officer wants to ask, well, haven't you been working such and so? I and my attorneys are instructed to shut them down. Officer, what is the relevance of this line of questioning? And we cite the chapter and verse from the law. Now, having said that, the employer, which is what the relevance of this question, is subject to sanction for hiring somebody without documents. Okay?
Thank you. Well, audience, thank you for joining me today. Please join me in thanking our panelists. Thank you. Thank you. Have a great day.
Hey, before we break up, Manny, if you could indulge me just for a second, this has been a really fast-paced news cycle. Okay, so we've been waiting with bated breath to see who the Homeland Security Secretary was. I mentioned it was John Kelly, who's former commander of the Southern Command. We're optimistic that things will work out there. I have what the Immigration Legal Resource Center calls their Family Protection Plan here. I just printed off a few of these. I was expecting maybe 10 or 12. I think we quadrupled that here today. But Manny, maybe you'd want to take one for an original, make copies. Anybody that needs those, there's about 10 of them here. Family Protection Plan isn't going out and talking to your insurance agent. It's what are we going to do if? And we cover everything in this document from who's going to take care of the kids, who's going to coordinate getting me some clothes in Mexico or wherever I end up, and all those sorts of things. Get another signer on your bank account. So take a look at that. This one is a practice alert. This is relevant specifically to the DACA program. This is more advice. This is a practice alert advising attorneys. I'm sorry, there's going to be some legalese in there, but this is going to lay out the law for you. And if you're working with another attorney and he doesn't have this, he should have this. This is both an English and a Spanish version of the consumer alert, basically know your rights. And just a little one-page thing. Okay, now,
Can we post those on our website?
What I'll do is I have a little sheet of paper here. If you'd like to receive one of these documents and we run out, you may put your email address here. I'll be sure that we scan them.
Let me clarify, Manny, if I may. These three documents are from the American Immigration Lawyers Association. Those, I believe, are okay. They're posted on the web. This one is from the Immigrant Legal Resource Center over in San Francisco, a wonderful bunch of people and advocates with us. You may want to just go to their website and print these down. ILRC is a website that anyone that's interested in this topic should have in your little dossier anyway. Beto, this is something that may be a surprise to you. I read this number, I reread it, I researched it myself. I was stunned to learn that in the federal district court system of criminal prosecutions, I'm understanding that 52%, more than half of all criminal federal prosecutions involve immigration, and primarily that's 1326, felony reentry after deportation. We've got a massive problem with our federal courts in this country. They're overloaded. We have a good share of the judges that are not being appointed, and Congress has come up with this creative way of trying to fill these federal vacancies by hiring more magistrate judges that are not Article III judges but still have jurisdiction over many of the misdemeanor and other matters. This is what's plugging up our courts unnecessarily. we could solve this problem with a little bit of immigration reform. It was just interesting. Did you know that 52%?
I know it was very high, very, very high.
Are dealing with 1325 and 1326 and other immigration-related. Two things just came out of the Ninth Circuit within the last few days. One is, actually, one is pending and one is coming out. The one that's pending, we are aware that the Ninth Circuit recently ruled that children in immigration deportation proceedings are not entitled to a right to counsel. So a group of ALA attorneys have filed another action asking the court to reconsider that. And here's kind of what that case grows out of. Down in Dilley, Texas, there was a 3-year-old child going before an immigration judge. He's got his little teddy bear, 3-year-old child. In the allegation on the Customs and Border Patrol complaint on the MTA charging this 3-year-old child is he's entered the United States seeking employment. And what's the kid going to say? Duh! So something's got to change here. Because they're not Article III courts, they're administrative bodies acting like courts. That's one change I think could be constructive, is making the immigration courts federal judges. But anyway, the other is just came out of the Ninth Circuit here, and this kind of gives you an idea of what kind of mentality goes on within the immigration organizations. But basically, the Ninth Circuit has just overruled the Board of Immigration Appeals, who said that someone being murdered is not necessarily persecution in their home country. So murder, according to the Ninth Circuit, now does qualify as somebody's been persecuted in their home country.
That makes sense.
Yeah.
Yeah.
Anyway.
All right. Thank you, gentlemen, once again, and thank you, audience. Have a wonderful day. It just doesn't make any sense.
No. Did we get too political?